Good afternoon, folks, and welcome to this week's episode of the Legal Beagle podcast. This week, we are joined all the way from New York by Cynthia Pigott. She's the author of what I will call the new best-selling book, Diary of a Mad Juror. And this is a fascinating read. But Cynthia, why are you mad? Why did you name it Diary of a Mad Juror?
Well, I'm not really mad, but at times I was mad during the trial, but mostly I was trying to think of a catchy title, and I thought of Diary of a Mad Housewife and thought it would be fun to play off of that. So,
Well, I love the way you wrote the book in the diary entry style. I think that's such a unique way to write it because as I was reading it, I felt like I was following each day's events along with you. Like you're at night penning your journal, and I'm there with you as you're writing this story. So let's jump right in. Tell me
okay.
what this book is about.
Well, it's about my experience as a juror on the longest trial ever held in uh, the borough of Manhattan in New York City, and my experience with my fellow jurors and my impressions of the lawyers and the legal system in general. And it was really although each day could get excruciatingly boring, the experience as a whole was really quite fascinating.
Well, speaking of fascinating, I was reading in the book that the I hate to use the word accident because an attorney myself, we usually call them crashes, but this was catastrophic in nature. What happened to these two guys? This
Yes.
happened originally in 2008. You were summoned for jury duty in 2014, and you remembered this actually happening back in 2008. Where were you at the time, or what recollection do you have of this catastrophic event?
Well, yes, it is an odd coincidence, and one that I actually thought might preclude me from being chosen for the jury because I live only a few blocks away from where the accident occurred. And I was actually on my way home from the gym that I go to, which is also in the neighborhood. And I saw a huge crowd of people gathered, and I joined the crowd and asked what had happened, and was told that a tower crane had collapsed, and the immediate area around the accident was roped off, so I couldn't get up close. But the following day, though, I was able to get within a few feet of the accident and see all the rubble, and it knocked off balconies from the building across the street, and it was really a big mess for quite a few days.
I can
Took
imagine. It sounded like it was an unbelievable occurrence that this would happen. And I like even how you started the book talking about one of I don't want to call them characters because they're real people, but one of the people that nearly missed being a victim in this situation. You talked about how she just saw this like giant object hurtling towards the ground.
Yes.
And then you really break the book into three parts. I mean, you have the civil trial that you sat on as a juror. You talk about the criminal trial, and then you talk about the investigation and maybe the misgivings in our judicial system as a whole. And I want to get to that, but I want to back up to something you said, because I think this is going to resonate with everyone that watches this podcast. When you first got that summons, you talked a little bit about how you kind of used up your goodwill in terms of getting out of jury duty overall. And that's the question I actually get asked a lot as attorney. How do I get out of jury duty? And I laugh and I said, you should go serve on the jury. It's important, but also it's sometimes can be really fascinating. When you first got that summons, can you think back to that moment in time thinking, I'm going to be part of history? I'm going to sit on the longest civil trial in Manhattan?
No, not at all, of course. I actually probably did not have the typical reaction to the summons because I had been a stay-at-home mother, and at that point, my oldest child had gone off to college, and my daughter was starting 10th grade. So I actually had some free time, and thought, well, very unlikely that I'll get chosen, but I can do it, right? I can take a few days off. So of course, never ever thinking that a few days would turn into 11 months. But I was not particularly perturbed about getting the summons.
Okay, maybe not as excited to be part of an 11-month trial, but you couldn't have known that going in, obviously. When you get into that courtroom, you're finally impaneled, which just means you're now part of the jury, and the attorneys start to talk to you. Did you already know that this case was about the crane, or were you not aware of that until opening argument or opening statement? Excuse me.
No, we did know in voir dire, the judge had told us the basics of what the trial would be about. And he had actually given us a heads up. He had said that the trial was going to last about 3 months. So, of course, that eliminated the majority of the people in the room. But even 3 months, I thought, well, it's it'll wrap up by Christmas, so I can do it if I get chosen. So
Okay, so
and
you get in there, set the
mhm.
scene for our audience. What is this case really about? I know we've kind of danced around it with a crane collapsing, but you really give us some detail about what occurred. I read it, but for those that have not read it, I don't want to give away everything because you have some really great nuggets in the book, but I want to talk about some of it. But let's just set the scene for what actually happened.
In terms of the accident?
Correct.
Yes. Okay. So it was just before 8 o'clock in the morning on May 30, 2008. And uh, around that time, just all of a sudden, a few bystanders did report that they heard a few strange noises, but the tower crane with the crane operator in the cab suddenly collapsed hundreds of feet to the ground. And the tower crane operator was killed, and a sewer worker who was working on a sewer line beneath the sidewalk on the side of the construction site was trapped under the crane, and he died a few hours later. The crane operator, the jury felt that he died pretty much instantly. We gave him 30 seconds. The plaintiff, the lawyer for the crane operator, tried to argue that he remained alive for about a half hour, but we didn't think that was possible. Um, and then the crane, when it fell, it scraped as it was falling. It scraped along the side of a condominium building across the street from it, and sheared many of the balconies off of it, and parts of it flew into the apartments in the building across the street. We actually heard testimony from one man who was lying in bed, and suddenly a piece of the crane flew through his window into his bed, and he was injured. There were as you can imagine, a lot of injuries as well as these two deaths. But that was litigation that happened apart from our trial.
So your trial was about the crane operator and the sewer
Mm-hmm.
worker that was down on the ground. Those two individuals, correct?
Correct.
And they were bringing
Yes.
claims against who?
Uh,
I know this answer, but I mean, you're the author.
Yes. Every defendant but the kitchen sink. It was, and apparently they made claims against a lot more defendants who were set aside before our trial began. So when our trial began, they were suing the owner of the crane and two of his companies. They were suing. There were two developers of the construction that was being built was a combination condominium building and school, and there were two developers of that. The condominium itself, an entity that was set up, an LLC, just for that condominium. The general contractor, who happened also to be one of the developers. The concrete subcontractor, a welding company that had done some work on the crane that collapsed, and the owner of the land, which was a New York City educational construction fund. It was a complicated arrangement where they allowed the condominium to be built in exchange for building the school for free, no taxpayer expense. So that's a lot of defendants.
Yeah, it's a lot of people. How do you keep that straight? How do you and your fellow jurors keep like your eye on the ball as things are happening and there's all these different parties involved?
That part was not difficult, actually. It was, we knew who was. It was pretty easy. We knew who was who. That was. There were lots of other things in the case that were confusing, but not that. That was pretty clear.
You mentioned in the book, and I wrote this down. You said that your perception of personal injury attorneys. You said there were two types. There's the ambulance chasers, and then there's the slick guys that are on TV. And this changed things a little bit for you in terms of the plaintiff attorneys for these two individuals in this trial. Where do you think that perception comes from in general? Not maybe for you specifically, but in general, because a lot of people feel that way.
Yeah. Well, I think the sort of slick thing, slick persona is probably mostly from the ads that you see on TV. From the lawyers always look, very well to do, and they talk about how they can get you so much more money than insurance can, and so I think that's that's pretty much the only impression that the general public has of personal injury attorneys, I think, is from, unless they've had some direct experience. And the ambulance chaser, I think, is just kind of folklore, kind of, right? I mean, just sort of, that's what you hear from birth.
Yeah, it's true. I totally agree with you.
Just an icon of iconic image. But I didn't have any, while I had those two stereotypical images in my head, I didn't have any, particular disdain for that type of attorney. Because I just feel like stereotypes are stereotypes, and people aren't, it could well be a fallacy. So, and as it turned out, while one of the attorneys did sort of fit the bill of the slick, I can get you a bunch of money type, the other two were not at all. And one of them I had extreme respect for. He was not, not like that at all. So,
well, that's good to hear.
Yeah.
Your husband's an attorney, correct?
Yes, he is.
Did you think that would preclude you from being on the jury, knowing that you had someone in your own household that had a legal background, a legal training?
I guess I thought it might. I did, reveal that in the questionnaire that we filled out. And what in voir dire, one of the plaintiff's attorneys did ask me what type of law he practices. And I told her, and, since he works for a nonprofit that develops affordable housing, I thought, well, since he's in housing, possibly, that is the same type of law, that might preclude me, but it didn't.
Yeah, you ended up on the jury. Did you have an admonishment from the judge that not to discuss this with family, friends, not to go look online? Is that kind of the standard practice from what you experienced as a juror?
Oh yes, every day he said it. Every single day at the end of the day.
Were
Um,
you guys, not to cut you off, but I want to ask, as a group of jurors, were you guys able to talk about it when you were back in the jury room, or were you guys not supposed to talk about it?
we were not supposed to, but as I talk about in the book, and as you can well imagine, uh, I can see how that would be very, a vow that would be easy to uphold in 99.9% of trials that are, just a few days or maybe even a couple of weeks. But in an 11-month trial, it's just, of course, eventually we did start talking about the trial amongst ourselves. And in fact, I was one of the last holdouts to try to keep my lips sealed. But I finally caved too after, several months. And as I talk about in the book, I eventually did start talking to my husband, but we had especially since he's a lawyer, we had a rule that I wouldn't say anything substantive about the trial, but he and I felt that it was okay if I talked about, just little silly anecdotal things like, one of the lawyers, his bald patch on top of his head turns bright red when he's mad at one of the other lawyers, or, little sort of the atmospherics of the trial. I felt we felt that was okay. And that was the only thing I ever, that sort of thing. Um, I did talk about, because, we're human beings. We just can't, 11 months, you can't, it's impossible. And I'm sure the judge and the lawyers must have realized that we wouldn't be able to hold out that long.
Yeah,
Right? Don't you
yeah.
think?
I mean, 11 months. I'm surprised people can hold out that long for 11 days. I mean, there are trials that last 2 weeks and people are talking to each other about what's going on well before the judge has given them permission to do so. Well, let me back up for a second, because I want our audience to know this, because again, there's a lot of misconceptions from what we watch on TV. Cynthia, you were not sequestered for 11 months. You went home every night, correct?
Yes,
Okay.
yes.
I know you don't say that in the book. I assumed it. It's very rare to happen in a civil trial. The only reason I bring it up is because people see movies and they're going to be like, this woman was in a hotel for 11 months. No.
Yeah, no, actually, it didn't occur to me to mention that, but no, it wasn't like the O.J. Simpson
Right.
trial.
Right. That's a great example where people like
Yeah.
are under lock and key and they can't leave. You originally were told 3 months.
Yes.
As this trial started to drag on, and I don't know if I use that word correctly, but you make reference to like some things that were happening that were delaying this. Were you guys starting to wonder if this would ever get done? Were you starting to wonder why it was taking so long to get this to closing argument?
Uh, oh yes, we around Christmas time, when it was still the plaintiff's case, and yeah, we realized, oh, this is no way, this is going to take a long time. And in fact, one of the jurors, Tony, I write about this in the book. He said, I think this is going to be a 4-season trial. And we were like, oh no, forget it, you're wrong. And he was right. It was a 4-season trial. And I think we actually kind of knew why it was taking so long. To my mind, partly it was no one's fault, in that there were 2 plaintiffs and 8 defendants. I mean, that's just a lot of players. So that's going to drag things out. but there was so much repetitive testimony. It was just unbelievable. And for example, when it came to proving that one of the theories, I should say there were two theories of the accident: one, operator error, and two, mechanical failure. And the mechanical failure was that allegedly some of the welding on the crane was defective. And when it came to proving that the weld was defective, there were pretty much almost every defendant put on an expert to say that the weld was defective. And they were just so repetitive and took just days and days and days. And it just drove the jurors nuts. Like, why on earth, why can't you guys pool your resources, just put on one good expert and do it and get it over with? I guess lawyers just, because a lot of the defendants were kind of in it together. So, but maybe that's just not a lawyer point of view to pool resources. I don't know. Maybe there's just sort of this adversarial urge that they can't overcome. What do you think?
Did you guys? Well, I want to ask this because that was an interesting point. I want to get into the experts as well and their actual testimony. But did you, as a group of jurors, did you hold it against either side that there was so much duplicative testimony?
I don't really think so. I think I held it against the judge. I really felt like he could have, I'm not a judge, I'm not a lawyer, I don't really know what the rules are, but it seemed to me that he could have streamlined things a lot. I mean, judges can give time limits, can't they,
Oh,
to lawyers?
they often do, and they hold you accountable. A lot of we have offices in 3 states, and it's different everywhere, and sometimes different from courtroom to courtroom. But they are absolutely the gatekeeper, and they can limit how much testimony and also strike certain witnesses if they feel it's duplicative. So you're absolutely right.
Yeah, and he just let everybody just. And then there was one plaintiff's attorney who was unbelievably long-winded, repeated herself mercilessly, and he just let her go on and on and on. And yeah, so, but no, I don't think we really held it against any particular plaintiff or defendant because they were all repetitive.
Sure. When it came to the experts and their testimony, and I know you talk in the book about there were experts on both sides. Did you feel like the testimony from the experts, aside from the duplicative nature, the repetitive nature of it, did you feel it was helpful? Did you feel it was not helpful? Do you feel it was kind of in between? Like, how do you as a juror perceive that testimony? That's a question that I always wonder as an attorney when I'm questioning an expert. Is the jury even picking up on what's happening? Do they even care?
Oh, well, I definitely we cared, and definitely was necessary. I mean, that was, very important to the case that we either it be proven or not proven that the weld was defective. So you have to put experts on to talk about that. But particularly the crane owner's expert on that. I believe I wrote in the book, I think he was on the stand for 11 days. And his testimony was very, very difficult to follow. Plus, he was kind of a kooky character, which didn't help matters. And his appearance was, as I say in the book, he was like somebody out of Duck Dynasty. Um, and um, but then there was one witness, expert witness on the welding for the welder, which came at the very end of the trial. And he was really good, from MIT. His testimony was pretty short, like maybe half a day, and very clear. And they should have just gone with him and skipped all these other experts, because he was good. The plaintiff's welding experts, it's sort of a blur now. I don't even remember much about them, but no, I do think that it's important, but they have to, make sure they speak in a way that a lay people can understand. And
I agree.
one thing too that is very helpful is visual aids, unless they're difficult, indiscernible. Like the one witness had cross sections of welding that were, he showed us, but they didn't mean anything to me. But if they're clear, that's helpful, because a lot of people, even like in when you're in school, there are visual learners and auditory learners. So the visual aids are good, helpful.
You talk about, and I don't want to give away the end because I want people to buy the book because I really do think it's a good read. You talk about, though, something in the criminal trial and a piece of demonstrative evidence, which is the visuals you're talking about, that was not allowed in the civil trial that you think could have been extremely helpful. To your point about using visual evidence to help explain stuff in a way that people can understand. I thought that was fascinating that you said, look, when your research after the trial was over and you went back and looked at the criminal trial, you're like, this evidence was never presented to us. We never got to see that.
Yes, that was an accident reconstructionist who actually, to be fair, the crane owner's attorney in the civil trial did want to put that expert on the stand in our trial, but the judge precluded him from doing so because he ruled that it was too, believe he said, too theoretical, and that it was at odds with eyewitness testimony. So he wouldn't let him put that witness on the stand, which was a huge blow for him. And actually, I found out afterwards that at that point, he tried. They had tried a few times before the trial and during the trial, but then once again he tried to settle with the plaintiffs because he knew his case was pretty much sunk. But he felt that the plaintiffs were still asking for too much. That was a big mistake on his part because they ended up getting more than they were willing to settle for.
Yeah. And you talk specifically about the damages that you guys awarded, which I will tell you, audience, you have to go buy the book to find out, because it's stunning. And you have to understand how Cynthia and her group of jurors came to that conclusion, which was fascinating to how you guys calculated damages, because you talked about at the beginning of this podcast that 30 seconds. And that came into the jury room and was a discussion about the pain and suffering of the crane operator. That 30 seconds mattered, right? The argument from the plaintiff was it was much longer and he suffered a much longer amount of time. And you guys really took some time to work through that. But earlier in the book, Cynthia, I highlighted this because I thought this was fascinating, because I want to believe this. And when you said it, I was like, oh my gosh. Quote, people are hardwired to root for the little guy, unquote. And you talk about David and Goliath in that story. Why do you think that's true?
Ooh, that's a really good question, Jonathan. Do you agree with me on that?
I do. And I believe, and I've always told all of my clients that jurors are trying to do the right thing, that they really do appreciate the little guy story. But I didn't have anyone confirm it until I read it in your book. And I was like, oh, I've heard other attorneys say it, but it's not a person who served on a jury and in this magnitude. And when you said it, I was like, holy cow, maybe that's true. Maybe that is really the way people feel. We root for the little guy.
I think so. I think that there's just something so, heartening about little guy wins over big guy battle. I mean, look at Ukraine and the Soviet and Russia right now. Who's not rooting for Ukraine? I
That's right.
mean, I just think that that's kind of how. So I, in a way, I feel badly for the defense attorneys in this kind of situation, because I think they have an uphill battle from the start. Unless, of course, if the specifics are depending on the specifics, if the little guy comes across as unlikable, or just trying to use the system to get a ton of money or something like that, then the David and Goliath bias goes out the window. But if the little guy seems like a good little guy, then I think that is a definitely influential, I think.
You mentioned defense attorneys, and at the end, when one of the defense attorneys was doing their closing, you referenced one of the attorneys trying to gain sympathy, and you were turned off by that. And I think you said your fellow jurors were as well. Why did that backfire? Why did that idea of trying to gain sympathy for the defendant as they were representing not resonate with you?
Are you talking about the crane owner's
Yes. Yes.
attorney?
Yep.
Probably when well, he was, he was in a very tough spot, because by the end of the trial, all the other defendants, or almost all the other defendants, had been either dismissed or settled with. So he was the last man standing. But he had a habit during the trial of sort of, what do you call that? Faux modesty. Like, he would, claim to be terrible at math, and or claim to not know anything about construction. And, when he was he clearly did. And I think that kind of put us off a little. That we could see through that.
Sure.
Um,
Sure.
but I mean, I did feel sorry for him, but it didn't make any difference in the end. But he did have he had it was a really hard case for him, particularly when he lost that accident reconstructionist. I mean, he was really sunk.
Yeah, and you break the book into, and I'm going to show it back here for our audience. You break the book into two parts, right? You have the first part and the second part. I said it was three parts because I thought your explanation of what you uncovered and your thoughts after all of the dust had settled were fascinating. And without giving away too much, because I really do think that's stuff that people need to read for themselves. You referenced this earlier in the book, and I thought this was a very polarizing statement. Quote, "The courtroom is not the place to look for truth." Unquote. That's a great line, Cynthia. Why do you feel that to be the case?
Well, it is a great line, and it's not mine. I stole it from the movie A Civil Action. It might have been in the book too. Really good book and movie, I think. But anyway, I stole that. But I really, I think, because of the fact that the judge and the law can keep a lot of information out of the courtroom, that makes it really hard to get to the bare bones truth. Maybe not always, and may depend on the specific case. But I did learn quite a few things afterwards, information that had not been allowed in the trial, and then things I learned from reading the transcript of the criminal trial that gave me pause about parts of our verdict.
You said that, I believe, if I'm remembering this correctly, that there were pieces of evidence or things that were not allowed into the trial that you later discovered that kind of kept you guys, the jury, in the dark about certain issues. Is that a fair assessment of kind of what you discovered after the fact?
Yes, and including, the fact that many of the defendants in the trial were not actually being sued by the plaintiffs. They were only there because they had actions against one another. And that was completely, uh, at least I don't know, maybe some of the other jurors were savvier than I am and had figured that out. But they never said if they had during deliberations. But I had no idea. I thought both plaintiffs are suing all the defendants. End of story. Seems like a fair assumption, right?
Yeah.
For a layperson. And in fact, that wasn't the case. And even in deliberations, we had to decide a percentage of liability for two of the defendants that at that point had settled with the plaintiffs. So the only reason for that, for us to apportion liability to them, would be so that after the trial they could claim, some sort of reimbursement money from one another or other. I don't know, extremely complicated. Take my hat off to you lawyers. I don't know how you it was, how you get through all that. But yeah,
Well,
that
you
that seems
actually,
crazy to me.
well, yeah, and
That
you actually, Cynthia, you brought up a party, and again, I don't want to give away the end because it's so good, but you bring up a party, and this is in your discovery process, your investigation after that. I don't think was a part of the trial that you said you felt was primarily responsible for all of this. Is that
oh
they weren't a
well,
defendant, were they?
no, I think you're talking about the manufacturer of the
RTR. Yep.
of yes, of the bearing that contained the allegedly defective weld. Yes, they were not part of the trial, and I found out afterwards that it's because this company is based in China, and one of the plaintiff's attorneys who agreed to be interviewed by me after the trial was over, he told me that it's incredibly difficult and usually fruitless to go after foreign entities, foreign parties, that would have been pointless to try to go after them. But when you think about it, they are kind of, that they committed the original sin, if that's what you believe, that the weld was defective. So, and then I don't know if you want me to talk about the other entity that was not
No,
sued.
save that. That's kind of
Oh,
not a
okay.
bombshell, but that is a aha, like what moment in the book that I think readers would appreciate discovering for themselves. Cynthia, what are your big takeaways from this experience? What are some of your feelings and thoughts towards the civil justice system now that you've done this and really gone way beyond what a typical juror would do, right? People, they end their jury duty service and they go about the rest of their lives. You actually spent time learning about the criminal trial that occurred before the civil trial, investigating a lot more that you discovered on your own that maybe could have been helpful to you and your fellow jurors, and then wrote a book about it, which again, not many people can say they did, and which I think is fascinating. But what are your takeaways? What are some of your big, like, these are your feelings towards the system and towards this process?
Okay. Well, I can't say that I think the system is terrible. It's not. I think that and in fact, I still believe, after all that I learned, that the that most likely the party that we found liable was liable. So in that sense, I think the system worked. But I do think that we our damages were way too high. And also of course, I think that the trial should not have taken 11 months, despite the fact that it was a complicated case and there were a lot of defendants. I still think that was ridiculous. But I learned a lot, and I mean, I do have I hold lawyers in high esteem, and even though I was given a lifetime exemption from further jury duty, especially now that I'm, retirement age, I would do it again for sure. So
Do you think
it was,
that? Do you think? I'll ask it. I want to ask this another way. Do you think that the outcomes are primarily correct? Meaning, I don't want to say that everyone always gets it right 100% of the time, because none of us do. But do you think primarily the outcomes are correct?
in civil cases you're talking about?
Well,
Or
yeah. Well,
all, yeah.
no. I think it's a good
Oh,
distinction. Yeah, let's start with civil, and then I want to ask that
yeah.
same question in criminal.
Um, I think so. Yes. I think that, in terms of who's liable, who's not, I think probably most of the time they get it right. In terms of damages, I don't know. As I say in the book, I really, when it came to the economic damages, that was not hard for us to determine. But the non-economic, the pre-impact fear and post-impact pain and suffering were incredibly difficult for us to figure out, because we had the only guidance we had was what the plaintiff's attorneys suggested, which were amounts that I thought were ridiculously high. And the defense attorney and his amounts were ridiculously low. So I really thought that we would get some guidance from the judge, possibly based on precedent, what had the amounts that had been awarded in for similar amounts of time of pain and suffering and terror in previous cases, which would seem like a logical thing to do to me, but he didn't. So, and then of course, there was an appeal and the damages were lowered considerably, and that's a good thing. I think they should have been lowered even more, but anyway, yeah, I think basically it gets things right. And I also know that most cases don't even go to trial, and so I don't know if settlements beforehand are correct or not, but
Yeah,
I think probably.
your guess is as good as mine. What about on the what about on the criminal side? Because you distinguish those two. Do you think we mostly get it right on the criminal side?
Mm. I hope so. There are just so many stories you hear about of wrongful convictions, but maybe you hear about them because they're sensational, and the ones that get it right you don't hear about. So maybe, hopefully, yes.
Yeah, you and me both. Hopefully.
Yeah.
The damages discussion, and your damages are the compensation, paid on behalf of the plaintiff's non-economic and economic damages. It's a tough thing for, I think, everybody, not just the plaintiff attorneys. I think the defense attorneys, I think the jury, I think society as a whole. Kenneth Feinberg wrote a
Mm,
fantastic book about how you value human life after 9/11, and
yes.
his really tough job of having to put a dollar amount on all those victims in 9/11. And that brought me to tears at times. It made me pause and think about the value of human life in different ways that I don't envy the position that you and your jurors were in. Like you said, economic is relatively a calculation, and that's not all that complicated. It's the non-economic that becomes really, really tough. And
But and you mentioned value of life. I think I talk about this in the book. I actually think that, of course, value of life is very difficult to determine as well. But if you're going to be talking about nebulous things, I'd rather talk about value of life than the dollar value of fear and pain. I don't know. Somehow, value of life seems a little more um, a more legitimate thing to try to put a dollar value on. I don't know. What do you think?
Yeah, I would agree with
I,
you. I think it's hard. I think all of it is very hard to calculate because there's no calculator for it. And so you're
right.
trying, without saying you're trying to gain sympathy, you're trying to help people understand what is lost and what that fleeting moment of time might have felt like. But you're kind of speculating in a way, right? I mean, that, as you guys talked about the period of time that this crane operator may have suffered. I mean, we won't know for sure. There's no way to know for sure. And so you do your best and hope that you got it right. The book is called Diary of a Mad Juror. Cynthia Pigott. This is a cool book to read. I'm going to put our link up so that our audience can find it and buy a copy. Before I let you go, I end every podcast the same. I do what I call Fast Five, which are 5 questions that I want to ask you. Are you ready?
I hope so. I'll try.
Question number 1. Do you know if any of your fellow jurors have read this book?
I know for sure that Tony did, and he was one of the police officers on our jury. Great guy. I know he did, and he because he asked me several questions about it, and he liked it a lot. I actually don't know if any of the others did. I would think they would. I would think they'd be interested. And I am in touch with some of them, mostly via Facebook, but I don't know.
Question 2, my wife wanted me to ask you this one. What is it like being married to a lawyer?
uh, in terms of having served as a juror or just,
Just in general. She said in general, because she's not an attorney just like you. And so she's like, ask Cynthia what it's
okay.
like being married to an attorney, because sometimes we forget what it's like to not be an
So,
attorney.
yes. Sometimes my husband thinks in terms of issues within our family life. He analyzes them in such a lawyerly manner that it drives me a little crazy sometimes, but basically that it's fine.
This this
I
is
don't know.
this is a question that people have asked me before. Were the snacks during jury duty, like the snacks they gave you back in the deliberation room, were they any good?
Oh, well, there were no snacks except for at Halloween. The judge brought in or had his clerk bring in a couple of huge bowls of candy, and then he continued to refill the candy bowls with throughout the trial. But I think if there hadn't been Halloween, there would never have been any uh, any snacks,
I
and we
mean,
never got. Yeah, go
you,
ahead.
you went through all major holidays, Cynthia. I mean, it was 11 months. You literally saw the entire cycle of one calendar. Yeah, you hit everything.
Yes. Yes. He could have gotten us a Christmas tree
Right,
or
right. 4th of July.
no,
I mean,
and
you could
in
have all
fact,
sorts of stuff.
I talk about in the book the Martha, one of the jurors. She was sort of our mom type in our among our jury. She brought a pumpkin in for Halloween, and it just stayed there until we moved. We never bothered to get any update our decorations, and it stayed there until we moved to a different jury room. And I talk about a funny incident about the pumpkin in the book, but yeah. And then we did finally, during deliberations, the jurors, I'm sorry, the lawyers pooled their resources and bought lunch for us. But the last lunch was really crummy.
Ugh,
It was.
ugh. So don't rely on the food if you're gonna be serving on a jury. 4th question: do you plan to write
Yes.
another book? I know this is your first. Do you plan to write another book?
Oh, I may do a book. I'm also I do watercolor painting, and I might do a book of my paintings of New York City. but I'm not sure, with some small descriptions. But no, at first I was thinking about something more serious, but no, I don't think so.
Okay. Well, hey, you have a feather in your cap. I've never written a book, and I was really excited to read yours. Final question, because you're in New
Yes.
York, favorite New York pizza place?
Oh, favorite pizza place. We actually have a good place just a couple of blocks away. It's just a deli called Heavenly Market.
That's
They have
great.
really, really good pizza.
Yeah.
You know, it's hard to find bad pizza in New York. It's
I've said
pretty
that
much
to people.
everywhere is good.
Cynthia, people ask me, I was born in New York, but I moved out to Arizona when I was a kid. But people
Oh,
ask me when
okay.
they go back, they say, where do I go? I was like, you're going to have to try hard to find bad pizza. It's all pretty good. I agree with you.
Yeah, it is. It is. Before you let me go, I just want to say one thing. I hope that you'll mention that I think my book is interesting to both lawyers and non-lawyers. I've had lawyers read it and enjoy it, and then I've had friends my cousin in Texas, who doesn't know a thing about the law and never has been on jury duty, she read it twice. She loved it. So I hope we can stress that it has an appeal for everyone.
I'll second that. And here's why, because our audience is comprised of both attorneys and non-attorneys. But from the non-attorney perspective, it's a fascinating story, just a fascinating story. And it also walks you through what that might have been like during that 11-month period of time for you. For attorneys, it gave me a list of questions that I could have spent hours talking to you about in terms of why a jury thinks the way they do, why you guys reacted to certain evidence, didn't react to other evidence, how you guys calculated damages. I think it's a great understanding of the jury dynamic. There are a lot of books in our profession that talk about the jury in a very esoteric way. This is actually a book from a juror in what you experienced and what your fellow jurors experienced from a firsthand perspective. That is rare to get that. So I would agree with you. I think it is an absolute must read for attorneys and a delight to read for non-attorneys.
Great. So that's it for everyone.
There you go, for everyone.
All of us fit into one category or the other.
That's right. Cynthia, thank you so much for joining the podcast. We'll see you again soon.
Okay. Thank you, Jonathan.